Well, Akilah Hughes was ordered to pay Carl Benjamin's legal fees resulting from her failed copyright lawsuit, obviously. Viva Frei, Montreal litigator turned YouTuber, vlogging at you from Lamal Bay, Quebec, while my wife shops for groceries and 2 kids sleep in the back of the car, and I think I may have reduced that to 1 kid. Now, there have been developments in the Akilah Hughes versus Carl Benjamin lawsuit, and for those of you who don't know, 30,000-foot overview. Akilah Hughes filed a DMCA takedown notice against Carl Benjamin, also known as Sargon of Akkad, for use he made of one of her videos. Carl Benjamin filed a DMCA counter notice. Akilah Hughes sued Carl Benjamin for copyright infringement for use he made of her video called We Thought She Would Win. Akilah Hughes runs a YouTube channel called Akilah Obviously, and obviously Akilah Hughes thought she was going to win against Carl Benjamin, but lo and behold, she did not win. She lost in style. The judge came down on Carl Benjamin's side and came down on his side hard, arguing that what he did with that video was quintessential fair use. The judge came to this conclusion based on arguments that Akilah Hughes herself raised, in that Carl Benjamin was mocking her through his use of her video. Mocking is necessarily a form of commentary and not copyright infringement, and therefore the judge came down hard on the side of Carl Benjamin. After Akilah Hughes' lawsuit against Carl Benjamin was dismissed, Carl Benjamin moved to recover his legal fees as he is entitled to do under the law. And Carl Benjamin just got judgment in his favor, ordering Akilah Hughes to pay for his legal fees for her failed copyright infringement claim against him. Now, incidentally, for those of you who may not know, I have done a few vlogs on this subject already. I'll include the Sargon of Akkad playlist right here. Give those videos a watch before you watch this one so that this one makes a little more sense. And interesting aside, I am officially Sargon of Akkad's mother's favorite YouTube lawyer. He said as much on one of his streams. If you haven't seen it, I'm going to link the audio right here and link to the stream right here. I am officially Sargon of Akkad's mom's favorite YouTube lawyer. Booyah. Now, the judgment granting Carl Benjamin's motion and ordering Akilah Hughes to pay his legal fees is an extremely well-drafted and well-reasoned judgment. That being said, it is still susceptible of appeal for 30 days from the date of the issuance of the judgment, so technically the delay to appeal expires, I believe, in early September, but nonetheless, the judgment is a good read, and we are going to read through it right now. I hear crackling in the background. Akilah Hughes, plaintiff versus Carl Benjamin, a.k.a. Sargon of Akkad, John Does 1 through 10, inclusive defendants. Richard J. Sullivan, circuit judge. Defendant Carl Benjamin, also known as Sargon of Akkad, brings this motion for attorney's fees pursuant to 17 U.S.C. section 505, following the court's dismissal of the copyright infringement action brought by plaintiff Akilah Hughes against Carl Benjamin and 10 John Doe defendants. For the reasons set forth below, the court grants Benjamin's motion and concludes that he is entitled to $38,911.89 in attorney's fees and costs. The judgment then goes over the background and procedural history, which we just did in the 30,000-foot overview, and which you will not need if you have seen all of my previous vlogs on the subject, so skipping to the substance of the judgment. Throughout the course of this litigation, Hughes prominently referenced Benjamin and the ongoing suit on Twitter. For instance, on December 8, 2016, Hughes tweeted that she had, quote, a Christmas present on the way, end quote, for Benjamin, referring to the lawsuit. On October 28, 2018, Hughes tweeted that she was, quote, currently suing Benjamin's white supremacist ass for stealing her content, end quote. 2 months later, Hughes referred to Benjamin in a tweet as a, quote, carnival baker, end quote, and expressed a desire to convince the crowdfunding platform GoFundMe to terminate Benjamin's campaign to fund his legal costs for this action and to, quote, bankrupt, end quote, Benjamin with a libel suit. And on February 12, 2019, Hughes replied to a tweet predicting that she would lose her copyright lawsuit by declaring that she was, quote, gonna take hundreds of thousands of dollars USD, end quote, from Benjamin. And this, ladies and gentlemen, illustrates 2 principles by which everyone should live. No matter how certain you are going to win, you should nonetheless be humble and respectful to your adversary, because you never know when you are in fact going to lose. And the second principle is don't take ongoing litigation matters to social media. It is just not a good idea. You know what? There's actually 3 principles. The third principle is draft everything as though a judge one day will read it, because you never know, a judge one day might read it, and if it doesn't read well in front of a judge, it might come back to haunt you. And then we get into an analysis of the criteria that the court is to consider when deciding whether or not to award legal fees. The court has jurisdiction over this action under 28 U.S.C. sections 1331 and 1338A. Section 505 of the Copyright Act allows district courts to, quote, award a reasonable attorney's fee to the prevailing party, end quote, in a copyright action. Although courts possess, quote, broad leeway, end quote, to award fees under Section 505, that discretion should be exercised with an eye towards furthering the Copyright Act's purpose, quote, enriching the general public through access to creative works. Fogarty versus Fantasy Inc. Then the court sets out and goes through the 4 principles elaborated in Fogarty as they apply to this particular case. While this is necessarily merely a holistic inquiry, the Supreme Court has identified several factors termed the Fogarty factors that help guide the analysis. Quote, frivolousness, motivation, objective unreasonableness, and the need in particular circumstances to advance considerations of compensation and deterrence. Should a court determine that an award of fees is warranted, that does not end its inquiry. It must then assess the prevailing party's requested fees to ensure that they are reasonable. The court then goes through the 4 factors, and Akilah Hughes loses on all of them. Here, Hughes' claims were objectively unreasonable, a fact that was clear from the face of the complaint and the videos at the heart of the dispute. The court highlighted that, beginning with the title of Benjamin's work, SJW Levels of Awareness, Hughes herself acknowledged that SJW, or Social Justice Warrior, is a term routinely used by Benjamin in a demeaning context to belittle proponents of perceived liberal social policies and stances. It was therefore unmistakable that the edited video was designed to highlight and critique Hughes' alleged lack of self-awareness, not to pass off her work as Benjamin's. And here you have to bear in mind Akilah Hughes' own arguments. She said that Carl Benjamin's video was insulting, demeaning, etc., which is necessarily not copyright infringement, but is necessarily commentary. So in her own lawsuit against Carl Benjamin, she effectively admitted that it wasn't in fact copyright infringement, but it was in fact commentary. She nonetheless pursued with this objectively unreasonable position that what Carl Benjamin had done was in fact copyright infringement and not commentary, and this is where it comes back to bite her. And it seems that the kid is awake, my wife is back with the groceries, and I have used up all my time vlogging in the Provigo parking lot, so I'm just gonna have to finish this at the campground. So,
and also, we got cupcakes.
Also, we got cupcakes. Back in 5. All right, I'm back, and now we're going to talk about the second factor, improper motivation, because Akilah Hughes was not short of that at all. Benjamin argues that Hughes brought this suit to silence her political opponents and critics and to generate publicity for herself. Motivation, like all the Fogarty factors, is not dispositive, but, quote, the presence of improper motivation in bringing a lawsuit or other bad faith conduct weighs heavily in favor of an award of costs and fees. Here, the court has little difficulty concluding that Hughes' dual goals in bringing her baseless suit were to inflict financial harm on Benjamin and to raise her own profile in the process. One did not need to be Nostradamus to know that those tweets that Akilah Hughes put out would come back to haunt her. Not only that, but the court itself warned Akilah Hughes of the fundamental flaws and weaknesses of her lawsuit, and she nonetheless persisted. And when I say draft everything as though a judge one day might read it, I love this passage of the judgment. Of course, evidence of respectful conduct and efforts to efficiently and inexpensively resolve a dispute can sometimes neutralize evidence of improper motive and bad faith. But while it is true that Hughes did make a settlement offer, in this case, the offer hardly constituted a reasonable effort to efficiently resolve the dispute. Hughes' lone offer to settle this baseless case for $46,000 came on April 10, 2018. By then, the court had already laid bare the weaknesses of Hughes' claims during the party's pre-motion conference in early March. As a result, the court finds that Hughes litigated with an improper motive and that she never endeavored to efficiently and fairly resolve the litigation. And even if Akilah Hughes does decide to appeal this decision, I don't see any court of appeal anywhere overturning this aspect of the judge's initial findings. And then the court goes into the third criteria of compensation and deterrence, and recall that Akilah Hughes actually seriously tried to argue that because Carl Benjamin successfully raised money on a GoFundMe campaign, she should not be ordered to pay his legal fees that he paid through that GoFundMe campaign. Which raises another principle of litigation. If you have good arguments and bad arguments to make, don't make all of them, because making bad arguments sometimes does more damage than good. Raising bad arguments can compromise your credibility, which can compromise the legitimacy of your good arguments. Hughes makes much of the fact that Benjamin's GoFundMe campaign raised over $120,000, much more than the approximately $40,000 he expended to defend this case. But that fact alone does not preclude an award of attorney's fees. Indeed, courts frequently allow recovery even where the prevailing party did not actually suffer financial harm, as in cases where a third party provided or paid for the prevailing party's legal services. Put simply, a litigant's good luck in having the financial wherewithal to defend against a frivolous suit, whether because of insurance, a GoFundMe campaign, a rich uncle, or a pro bono lawyer, does not automatically immunize the losing party from the consequences of her actions. At the end of the day, you can't argue with good logic, and this is just good logic. I mean, you can argue with it, but you're not going to get very far. It's not because Carl Benjamin raised money on GoFundMe that Akilah Hughes is absolved of her liability under the law to pay his legal fees. And the court then goes on to highlight that compensation is not the only thing to consider. One has to also consider the deterrent factor. While Benjamin may not be out of pocket any money, awarding fees will still further the important goal of deterring Hughes and other would-be litigants from engaging in similarly abusive conduct in the future. An outcome that is tightly aligned with the Copyright Act's goal of of facilitating the general public's access to creative works. In short, Hughes endeavored to profit from an objectively unreasonable and frivolous suit by promoting her online profile while at the same time forcing Benjamin to wastefully devote time and resources to defending a baseless action. Since the goals of the Copyright Act are more likely to be advanced by an award of attorney's fees, the fact that Benjamin had the support of third-party contributors through his GoFundMe campaign, though relevant, does not insulate Hughes from paying an award. Accordingly, the court will order Hughes to pay Benjamin's fees and costs for this litigation. The court then goes on to analyze the fourth condition, that of the reasonableness of the attorney's fees, and this is where Carl Benjamin's attorneys are going to feel pretty good reading this judgment. Having determined that an award of attorney's fees is appropriate, the court must still assess whether the fees sought by Benjamin are reasonable. In this circuit, courts calculate a reasonable fee, quote, by determining the number of hours reasonably expended on the litigation multiplied by a reasonable hourly rate. Benjamin's lawyers, Mullen PC, charged the following effective hourly rates for the attorneys and law clerks who worked on this matter. $446.09 per hour for Wesley Mullen, the principal attorney of the firm and an experienced litigator who graduated from Harvard Law School in 2007 and was admitted to practice in New York in 2008. $300 per hour for Patrick O. of counsel at Mullen PC and an experienced litigator who graduated from Columbia Law School in 2006 and was admitted to practice in New York in 2007. The court then goes on to list rates that have been deemed appropriate or reasonable by the courts, and I'm thinking that Carl Benjamin's attorneys probably could have claimed more, but it's probably better off that they didn't. When seeking justice, one does not want to look greedy. And bottom line, the court concludes as follows. The court also finds that the hours expended in this case, 57.5 hours billed by Mullen, 16.5 hours billed by O, 43.4 hours billed by Perlman, and 17.2 hours billed by Wynn, were reasonable, and Hughes does not argue otherwise. Given the nature of the issues and the quality of Mullen PC's work product, the court finds that the time expended fell within the range of, quote, what a reasonable paying client would deem necessary to litigate the case effectively. Conclusion, in light of the findings set forth above, the court agrees that full fees and costs should be awarded. Accordingly, it is hereby ordered that Benjamin's motion for attorney's fees is granted. Benjamin is awarded $38,785.35 in attorney's fees. Benjamin is also awarded $126.54 in costs. Now, I noticed on Twitter some people were confused about the attorney's fees versus the costs. What was that $126 cost? Well, I suspect that was just a filing fee for one of the procedures in the context of this motion. Literally a court fee to file a document. The rest were the attorney's fees, and that is the bulk of the claim. And that is the decision in all its beauty. Now, like I said earlier in this vlog, there is a chance that Akilah Hughes actually appeals this decision, and from what I understand of the applicable law and procedure, if she were to do that, any additional legal fees that Carl Benjamin incurs in defending against the appeal will be added to the award. So there may in fact be some financial incentive or financial deterrent not to follow through with a baseless or fruitless appeal. We will see what happens, but as they say, pride goeth before the fall. But the sun is setting, my battery is going dead, and I hear kids screaming in the background, so I had better get back to some parenting duties. If you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Subscribe, Star, Patreon, merch, if anybody's interested in some merch. But above all else, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, enjoy what's left of the summer, and now you know your vlog. Peace out. Oh yeah, no, hold on. Before we get there, I was just on Twitter, and apparently Akilah Hughes has been tweeting like crazy today, and actually tweeted something about the judge. I'm just gonna read this tweet. It says, also, please vote so that more judges like this aren't appointed. Typically, one would learn from one's mistakes of not only taking a current litigation to social media. It's not a good idea to target the judges who are rendering the decisions in your court file. Okay, whatever. Peace out.